Good morning. I am Victoria. I am one of the estate planning attorneys with the Kopenbarger Law Firm. I do primarily work up in our Northern California offices, so that would be San Jose, Sacramento, and then Santa Cruz. But we have attorneys in all of our offices, and for those of you who are not near one of our physical locations, and I will go over this again, we also can do Zoom. So if you are more comfortable or need Zoom, let us know that as well. To get started, for those of you who don't know us already, I want to give you a little bit of an introduction. So not only are we one of the largest estate planning firms in the state, we are also one of the most comprehensive estate planning firms in the state. By that, I mean we do more than just estate planning. So when many people come to us at first, they want to talk about their estate plan. What do I need to make sure I'm protected and my family's protected if something were to occur to me, either incapacity-wise or I actually passed away? But then at some point or another, we do unfortunately all pass away. And so we also have an estate administration department and team. This department and team is designed to make sure that after someone passes, you have a resource to go to where someone can help guide you through not only what practically you might need to do after a loved one has passed, but legally what needs to be done after a loved one is passed. And they're able to take a lot of the weight and burden off of those people who are in the position of doing what is called an administration of an estate, basically wrapping it up when someone passes. So that's one other department that we do offer. We also have a business and tax department. So for some of our clients, they own their own business. They know people that own businesses. For most of our clients, they want to make sure that they or their family don't pay any more in taxes than they absolutely have to. And then we have people with some charitable giving intents and more. And we're able to also assist all of those people with that business and tax department. So again, this is a very comprehensive estate planning firm. For those of you who have been with us for a while, hopefully you knew about those departments. And if you didn't, now you do. We also have an incredible staff. So we have probably one of the largest, if not the largest staffs for an estate planning firm in the state. And this is what allows us to really help the number of clients that we have. These are the people that make our jobs as the attorneys so much easier because we know that our clients have their questions answered in a much more timely manner than many other firms, and that we are able to do quite a bit more for their needs. So this group of people is why we are able to do what we do. And then, as I already mentioned, we have a number of offices. So for anybody who is in one of our locations, the good news is that we can absolutely meet in person. But again, if one of these locations is still just enough outside of your area that it wouldn't be convenient, or you're just not comfortable coming in person, we can do Zoom, phone calls, anything that you would want to make sure that your needs are met and that your questions get answered. So we are going to go through quite a bit of information in a relatively short amount of time. This really is trying to make sure that you get your feet under you to understand what changes in your life or in your plan may impact you and that plan, and what do you need to really pay attention to. Again, we will also go through the basics of estate planning to make sure for anyone who doesn't have a plan, or maybe you don't have all of the documents we're talking about, you'll have a good understanding of what those are and why they're important. As I had mentioned at the very, very beginning when everyone was first joining, if you have any questions or anything comes up during this webinar that you want addressed, please feel free to put them in the chat and the Q&A, and I will do my best to get them all answered today. So let's get started. So first and foremost, what is an estate plan? What are the documents that are involved? Why should you have them updated? And really, why are they so important to have in place and kept up to date? So when we're talking about an estate plan, we're not just talking about one document. Whenever I see a prospect come and talk to us and they say, I already had an estate plan created, can you review it? And they bring me one document, I can pretty much guarantee they're going to be left vulnerable in some way, shape, or form, or their family will be. Because each of these documents you see on the screen have an extremely important role to play in protecting you, your assets, and your family. So any attorney, estate planning attorney that you work with, if they are not covering more than one document or even just two, there's a very good chance that there are going to be holes left in your protection. So first and foremost, the document that every single person over the age of 18 needs, and needs since 2004, is an advanced healthcare directive. If you are somebody that had created a healthcare directive before 2004, this is really important for you to keep in mind because those documents are actually now invalid. But what is a healthcare directive? A healthcare directive is there so that if you could no longer communicate your wishes to a doctor, you have given somebody that authority to act on your behalf. I mentioned 2004 very, very specifically because after 2004, HIPAA laws went into effect that said nobody has an automatic right to make your medical decisions. Not a parent, not a child, not even a spouse. So if you cannot give verbal authority to somebody, you have to have it in writing. Now, there are some doctors and nurses that will fudge the rules a little bit to make sure that if you don't have it in writing, you could still have an advocate. The problem is, legally, they would be opening themselves up to a $250,000 fine if the family went after them. So what we have found is doctors who have either been sued or are scared of being sued for $250,000 take this extremely seriously. This is one of those situations that if you are in a vulnerable state, the last thing you want or your family is going to want is to be told, sorry, we can't even tell you what room of the hospital your loved one is in. So it is so important to make sure that this is a document that is in place before that event happens. But it's also important to make sure this is kept up to date. If you are in that vulnerable position, I would assume you would want the person applicable and appropriate to be serving in this role. If you had originally named a spouse, let's say 15 years ago, and you've unfortunately gone through a divorce, hopefully, or I'm assuming I should say, you do not want that spouse still to be making your medical decisions. So that is why it is important to make sure these documents do stay up to date. And we recommend you have them reviewed every 3 to 5 years, just to make sure you have the peace of mind that yes, it still honors your wishes and it still has the person or people you would want in it. The document that goes hand in hand with that one is the financial or durable power of attorney. This is again where you are in a position that you can no longer manage now your finances. So you are incapacitated in a way, whether temporarily or permanently, that would not allow you to manage your finances. So this is where you give somebody the authority to do so. This is an extremely helpful document, not only to make sure that your financial life and your just bills and everything else continue to be paid and moved along, it's also a huge weight off for the family. A few of the situations we have dealt with are for people who don't have this power of attorney. The family is stuck trying to pay out of pocket to cover those expenses because they can't get access to the loved ones. Or on the inverse, if you do have this document, again, it allows them to use your resources and gives them the peace of mind that they can continue your life as easily as possible without disrupting their own to a greater need than is absolutely necessary. So again, it's really important to not only make sure you have this in place, but also again, that the people you have in here are still current in who you would want. But it's also extremely important to note that now, especially since COVID, banking institutions, brokerage houses, they are enforcing what is called the FINRA rule. That rule is essentially designed to ensure that there is no elder abuse or financial fraud being done against accounts and against what you have. So they are requiring and will not actually accept these documents if they are older than 5 years old. So if you already have one in place and it is older than 5 years, it is time to come in and get this updated. Because if you have it, but it's older than 5 years, it essentially has become irrelevant. So again, that is a really good time to think about, do I need to come in and get this updated? Then the next questions we hear are, do I need a will or do I need a trust? And what the heck is the difference between the two? You probably hear more people talk about wills than trusts. And in part that is due to Hollywood talking about will readings and what did the will say? And really not much is talked about when it comes to trusts. But the people who need a will is actually a fairly limited scope of people, for at least the people we generally meet with. If you own a piece of property or you have assets greater than $184,000, a will is not going to be enough protection for you. But even for those people who don't have property or have less than the $184,000, it is really important to note that when you pass away, even with a will, you have to go into court to have everything administered according to your will. The goal of estate planning in a large part is to avoid the court's interference. It is to keep everything in your control and your hands and never have the need for you or your family to wind up in court for them to ultimately decide how things will be carried out. Now, for those of you who do own property or have more than $184,000, you absolutely need to consider setting up a trust. Because if you don't and you only have a will, again, your estate has to go through probate. Now, probate is there essentially to settle everything up. They're making sure that after someone passes, any debts that were owed are paid off. Any monies that are owed to the person who passed are paid into the estate, and then ultimately deciding where title and all those assets are going to go. Now, one of the biggest issues with probate is not only the length, but also the cost. Probate is an extremely lengthy process. Since COVID is taking an average of 2 to 5 years to settle somebody's estate, which basically means the family is waiting 2 to 5 years to have anything distributed. That money is just sitting there waiting for the probate process to wrap up. The other big issue, though, is the cost. So if you go to copenbarger.com to our resources tab, which I'll put in the chat just as a reminder, you can actually see that we have a probate calculator. If you are curious about what probate would cost your estate if you either don't set up a trust or you didn't set up a trust, you can see what that number would look like. On average, for a home that has a gross value of $1 million, that fee is going to be about $46,000. That is astronomical, and the good news is it is avoidable. So then the question becomes, well, how the heck do I avoid that? I don't want my family to be paying any extra money to the state, frankly, and even to your attorney than is absolutely necessary. So the good news is that if you have set up a trust or you are going to set up a trust, that is the step you will take to make sure that probate is avoided. So what does that actually look like? So a trust is a contract that you, as the creator or settlor, sets up, and you get to determine who would manage things on your behalf if you no longer could, and ultimately where your assets will transfer if you have passed away. So everything is in your hands. If you have already set up a trust, it is very important to, again, have this document reviewed every 3 to 5 years. Because we see quite frequently that managers change or the trustee changes and beneficiaries even change because life changes, relationships change, and as a result, the document has to change. Now, one of the biggest benefits of your trust is, again, avoiding that cost and delay of probate and making sure that your privacy is protected. The nice thing with a trust is the only people that are entitled to see that document are the people that you essentially have designated would benefit from your estate after you have passed away. No one else has to see it, and no one has to see it while you are alive. So for many of my clients, they don't want their children to see who's getting what or when. They want that to be something that is only shared after they are gone. It also allows you to do significant tax planning. So for those of you who have tax concerns, which actually ends up being most of our clients, your estate plan is able to make sure that any tax concerns you have are addressed. Now, the reason I say that this affects most of our clients is because there are so many different types of taxes. Most of the time when we start talking taxes, people go, I don't have an estate that's of a size that I'm worried. But again, there's a number of taxes to consider. There is what is called the estate tax. That is the death tax, essentially, where the federal government will look at the value of your estate. We will look at the current estate tax exemption. And if you are over the estate tax exemption, unfortunately, there is a tax on your estate. If you are under it, good news is there's not a tax on your estate. There's also capital gains taxes to discuss. So that can deal with, when do I transfer a piece of property to my children? When would I transfer stocks to them? Should I do it now, or should I wait until after I've passed away? There's property tax considerations to go through. There can be gift tax considerations. There can even be income tax conversations. So each of these components can play a part in your estate plan. And so if you already have a plan, but something that I've talked about has triggered a concern you want to make sure either gets addressed or verify you have already addressed, definitely come and talk to us. But again, our goal with every single thing that we do is making sure your wishes are the ones carried out. It's in part why we do so many education events throughout the year, is we want to make sure you have the tools to understand what information would be necessary to make informed decisions. So all of your wishes and goals are the ones that we actually accomplish. The only downside to a trust is that it only protects what it owns. So I'm really going to talk to people who already have a trust, because this is something that I want you today, if possible, to double check. When you establish a trust, there are certain assets that need to actually be transferred into the name of that trust. This, generally speaking, includes your real property, any checking accounts, savings accounts, and non-retirement stock or brokerage accounts. So again, real property, checking, savings, non-retirement stock. If those assets are in your name alone, not the trust, not even in a joint holding, and you were to pass away, those assets unfortunately are still going to have to go into probate. So this is where, again, I ask every person on this that already has a trust, go and double check those assets. And if you don't know what to look for, or you're not sure, come in and talk to us. I also want to flag anybody that has already set up a trust and had put property in, but has since refinanced. There's a very good chance that the refinance company pulled your house out of the trust, and it's very unlikely that they put it back. So if you are in that situation, I strongly recommend checking your deed. And again, if you can't or don't know how to, come and talk to us. We are happy to do that for you. Now, the good news is, though, if you do forget to do something, or you have an event that triggers the asset not being in the trust anymore, we create with your estate plan and with your trust a safety net document, and that is in the form of your pour over will. Your pour over will is there to make sure that if something has occurred where an asset wasn't in the trust when you passed away, it essentially tells the court in one hearing, rather than a full probate experience, to give that asset back to your trust and administer it according to your trust and get it out of the court. So again, we understand things happen, people forget things, people choose just flat out not to do certain things. That's okay. We want to make sure you understand you will still have an element of a safety net. Now, I do see one question in our Q&A, and that's asking about timeshares. Timeshares are extremely dependent on the timeshare itself. If you have a timeshare where it is a deeded property, generally speaking, we will then talk about actually putting the deed to that timeshare in the name of the trust. If you have a timeshare, though, that is more point-based, a lot of times those things just transfer automatically. The value on point-based timeshares is normally nominal enough. The timeshare company just says, submit the trust. If it goes equally to your children, the points go equally to your kids. It'll essentially follow that way. But on timeshares, I also generally recommend you talk directly with the timeshare company to see how do they transfer things after somebody passes away. All right. Now, a lot of what we have talked about is the practical, and it focuses a lot of times on the monetary components of your lives. But the other half of you is the emotional side of things. It is your stuff that actually often has a lot of emotional value. So what I'm going to focus on specifically is the line that says distribute personal effects. If you have a Kopenbarger trust, there is a section in your trust that says if you want to give a personal item to anybody, all you need to do is in your own handwriting, say what the item is, name who it goes to, and sign and date it. You don't need a witness, you don't need a notary, and you can do as many of these as you want, and you can get rid of them whenever you want. This is something that not only allows you to have a significant amount of control, it's actually a very helpful tool that we have found for families to remove fighting that occurs over the stuff when someone passes away. What I hear more often than not from clients is my kids don't want anything. They say just donate it, get rid of it. They don't care. And that's probably true while you are still alive. But what we see pretty consistently is the second a loved one passes away, their stuff becomes them. And when that happens, there is an extreme emotional attachment, especially while the grieving process is still fresh, that gets placed on those items. And so even if the kids are saying, I really don't want something, if you think there would be an emotional value to them to have it, you can then just designate that item, and then they can decide after you've passed away if yes or no to keeping it. The other thing that can really help with items that have a value to you and you think would have value to your family in future generations is write why. What is it about that item or that thing that you think has that emotional value? A lot of times that allows something to go from a thing to something that actually means something for that family. So the question I just got is, does the letter of instruction need to be handwritten? And for our purposes, yes. Now, some people, they have such an extensive list, they will type it up. In good families, I will say that is not something that will be challenged. But in families that have any amount of conflict, and I mean any amount, it's unfortunately, if you don't handwrite it, if you have typed it, there's a lot of times question as to whether it was actually you who did it or not. By handwriting it, you take out that question and you make it clear you're the one who designated it. Now, you can also, though, print, you could do pictures alongside of it. So there's other ways to make it a little bit easier. But again, the handwriting allows your kids or whoever's inheriting to verify it was you designating that item. I can speak actually from some personal experience with this in my own family. Not everybody gets along. And after my grandma passed, there was question as to who got what when it came to the stuff. And had she not had a handwritten list, I guarantee that would have ended up being a point of contention. All right. So now I'm going to transition and really focus, especially for people who already have an estate plan, which is where we're going to talk spring cleaning. So as we're going into spring, and despite the fact it's still very winter feeling, we are moving into spring at this point. And for many of us, we go through a spring cleaning phase. We want to start out the spring and the summer with a cleaned up house, with a cleaned up life, and hopefully a cleaned up estate plan. So what are some of the things that you need to focus on when you're going through your checklist? So for many people, when they first came to see us, they had minor children. This has been a big life trigger for many people. If when your kids now have become adults, you haven't come to see us, your documents are likely out of date to some degree. So there's a couple things with this. First and foremost, it is really important to note that when your children turn 18, they're legal adults, which may be a scary thought for some people, but it's also really important to keep in mind that you have lost the ability to make their medical and financial decisions without having some written authority to do so. So when your kids turn 18, the best gift, frankly, that you could give them and even give yourself is to get them, especially that healthcare power of attorney. Make sure that if they had a medical crisis, which young kids, unfortunately, they don't always make the best decisions. And so things and accidents can happen. You want to make sure that if that occurs, you have a document in place that would have somebody, whether it's they've designated their parents, their sibling, their friend, somebody could go in and advocate on their behalf if something were to occur. So if you have children that are over 18, again, you can either directly gift, you can say, go see Kopenbarger, we'll cover the cost, just go get this done. Or we're happy to talk to them directly about what it would cost to put into effect. But it's important to make sure that they are now going to continue being protected once they've hit that 18th birthday. But we also then look at, okay, now they are a legal adult. Are they at a point that they could actually start filling the roles that you had previously had in other people's hands? For example, your successor trustees. This is again who would manage your estate if you were either incapacitated or the person in charge of administering it after you have passed away. If they are over the age of 18 and they are of, I will say, a mature mindset, so just because they're a legal adult does not necessarily equal maturity, but if they are in a position that you think they are the appropriate person to handle it, we can make sure that that gets up to date. They may also be the people who now determine, are you capable of serving as your trustee? One of the roles in our Koppenberger Trust is what are called incapacity determiners or competency determiners. Essentially, these are the people who take the place of a judge. So the judge and the court never have to get involved, and they determine, are you still capable of serving as your own trustee? If you don't have these people in place or they're not current, the court does have to make that determination. But again, maybe now this is where your children or other people should be serving in that role. And of course, your medical and financial powers of attorney. Are your kids now the people, again, that you would want to make your medical decisions or financial decisions if you couldn't? We also on here mention the right of first refusal. This is actually tying into your property taxes, which I'll talk more about on the legal updates portion of this. But really quickly, if you are concerned about making sure your property taxes are maintained for your children, unfortunately, there's only very limited ways to do that at this point. And once your kids are adults, that needs to be part of the conversation. Now, when we're looking at which of your kids should serve in that role, sometimes it's just who's frankly the smartest. And I don't mean that just on intellect, but the smartest in a financial or medical field. So for some people, when I talk to them, they say, my child falls apart in every medical situation or emotional situation. That's probably not then the appropriate person to have making your medical decisions if they would become a complete wreck. I also talk to them about who should be your financial manager. If it's somebody who maybe can't pay their own bills, it's probably not the appropriate person to then trust with paying your bills. And then the inverse, if you have a child who's extremely responsible, extremely good under pressure, who understands how to compartmentalize and prioritize, that's probably the best person for the job. All of that is to say, these are conversations we want to make sure you have so that those decisions are ones you can make, nobody else. All right, and then are your beneficiaries still the same? So this can have a slew of reasons to come in and have updates. That could be you got married, or unfortunately you got divorced. It could be if you have married into a blended family, there may be different distribution schemes you want to talk about. Maybe when you first set this up, you had a really good friend that you absolutely wanted to inherit if you were gone, and now that relationship has kind of disintegrated to a degree. Or vice versa. There's somebody in your life now that is really like family that you would want to make sure inherited something when you go. Your assets have changed. Or maybe it's somebody who has now a substance abuse or addiction problem. There are a ton of reasons to make sure your beneficiaries are up to date. And these are just a few of the triggers that can cause you to come in. With beneficiaries in particular, again, I really do recommend having that reviewed every 3 to 5 years, because especially if you had had minors who became adults, you have adults who are now married, you have charities, these are things that can really trigger larger needed changes. And so those are reasons to, again, come in and get a review. And then again, are the beneficiaries still the same? So this is looking more specifically at what type of planning is available. So if you now have minor children, and maybe you didn't before, you can put in effect what are called minors trust provisions, basically making sure that if, God forbid, you passed before your child, hit 18 years old, who would not only take care of your child, but what would the parameters be around the money that would be inherited? Would you want them as soon as they turned 18 to receive every penny of their inheritance? Or do you want it spread out over time? Would you want it managed on their behalf until they hit 35, and then they could have the entire amount? This allows you to extend inheritance protections beyond the point of 18 years old. Then for those children who are now adults, well, they might still need protection too, whether that's from outside predators or even from themselves. And you can do that by putting what are called generation skipping trust provisions or dynasty trust provisions in effect. Basically saying no one can take their inheritance away from them, not divorce, not lawsuits, not creditors, not bankruptcy, and not even the IRS. So it protects that inheritance for their benefit and says at the end of their lifetime, it would go to your grandchildren free of tax. So it ensures again that there's a legacy, a dynasty being established for that inheritance. Then about your charities, there's a lot that can be done with charitable giving, charitable distribution. For a lot of our clients, we are creating what is called an exhibit that they can actually change as life goes on to make sure that their charities are kept up to date, because we understand that can change quite frequently. What if you have pets? This is a often overlooked beneficiary, but when you have a pet, generally speaking, you would want to make sure that that pet is going to be cared for if you passed away. And one of the ways to do that is by actually providing for them within your trust, whether that's naming who would take them and or leaving a sum of money for whoever that person would be. For legacy planning, we start looking at your grandkids. Are there different things you want to set up for them? And especially if you have special needs beneficiaries, a very often misunderstood thing is that if I have a special needs child or beneficiary and they're on government programs, they can't receive an inheritance because it would disqualify them. But using a special needs trust, they can use the inheritance to supplement the government benefits so they get the best of both worlds. For the question I just got, how do we update the addresses of our successor trustees? That is extremely easy. So if you have documents where the addresses were already within them, kind of just ignore that piece. We now actually create a separate names list that goes through the addresses, and it's just a helpful tool. There's no legal components to it. So you can simply let us know what those are, or even write or type a separate sheet of paper that has the name and then the corresponding address, and you can keep that up to date as life goes on. All right. Then we look at, have you had any financial changes? Oops, sorry. So I mentioned refinancing a home is a huge one. So if you've refinanced, it's important to make sure that that property was put back in your trust. But what happens if you've purchased a new home? Did you remember to immediately take title in the name of your trust? If the answer is no, then a deed would need to be prepared to make sure it gets transferred in. Maybe you sold property. So then the question becomes, what have you done with that cash? Are your cash accounts that we talked about earlier in the name of the trust? Generally, we like to keep assets up to date, not only in your own documents, but in our records as well. If you have a Koppenberger trust, you have schedules of assets in those last 2 to 4 pages of that document. Those are extremely important to keep up to date for 2 main reasons. One is it says, if again, you forgot to put that asset in the name of the trust, there's a paragraph at the top that says your intention was that it go into the trust. So that helps with the pour over will that we talked about a little bit ago and reaffirming everything should go through. But the other reason to keep these up to date is for whoever is your trustee when you are gone. That gives them a list, a comprehensive list of which assets you had and what do they need to go track down. When my grandma passed, she had a trust that unfortunately the attorney who prepared it had said all of her assets were in the trust. That was a one line. And unfortunately what that meant was I had to figure out what those assets were. Now, my grandma was someone who kept every piece of paper she had ever had. And so I basically had to call every institution that I found in her house that had a statement to verify was it open or closed. And so by having that comprehensive list, it cuts out the need for your family to do that. All right. For the handwritten letter, so going back really quickly, so the question is, can the handwritten letter contain any item? So for personal items, yes, but not cash, not real property. But your stuff, including vehicles, yes, that handwritten letter can designate those items. And then can Kopenbarger serve clients out in Utah and Colorado? If you have already established a California relationship with us, the answer is yes. So as long as it's based at some point or another in California, and then you've moved or something has occurred, we can still absolutely be your attorneys. All right, and thank you guys for putting the questions in. Keep them coming. This is great. All right. Now, another huge life change that unfortunately is becoming more and more prevalent is your health. Now, I'm going to pause for 1 second. So the question is, where in the trust should the bank accounts be itemized? So if it's a Kopenbarger trust, it's the last, if you're a single person, you have 2 schedules of assets. They're the last 2 pages of your trust, generally. And if you are a married couple, it'll be the last 4 pages of your trust. But if you have specific questions on that, or you can't find them, sometimes things get out of order, just come make an appointment. We can go through those. Another question about can we serve clients in Idaho? Basically, it's the same for every state. As long as we've established a California relationship with you at one point or another, we can continue to be your attorneys. We have clients at this point who are all over the country, so we can definitely keep serving you. So going back to the health component, when we're looking at health, there's a variety of things that come with this. Not only is it important that you understand we get incapacity, not only from the legal side, but also many of us on the staff and the attorney team have dealt with this in our families personally. So if you are in a caregiver role, come and talk to us. This is something we are unfortunately intimately familiar with. But it's also important to think about when you're looking at who would be the person in charge if you became incapacitated. Most people who become incapacitated aren't easy, I will say. And the reason is they often lose the control that they've previously had, and they lose the ability to communicate in the way that they need to keep the person in charge informed. And so it's important to make sure that whoever you have named, again, has a good head on their shoulders, that in this situation, they're not going to completely melt down. It doesn't mean there won't be stress. It doesn't mean that there won't be hardship. You just really want to make sure that you are setting them up and yourself up for the best chance of success. Now, one of the things to do that is making sure you have those documents that we talked about not only in place, but also up to date. If you do not have your powers of attorney, so again, the medical and the financial in place and current, and you became incapacitated, unfortunately, then the court has to step in and appoint the person or people who would be in those roles. So by already having those in place, you make sure that that is avoided. Again, we are seeing that some of the top concerns across the board are people becoming ill and as a result, losing the control. Now, there's a lot that you can do, though, to set yourself and your family up for success. I already mentioned making sure the documents we've talked about are in place and up to date, but also now we're looking at how to protect you and your family from the cost associated with long-term care. Again, the statistics, and I won't go through these in depth because they're frankly more depressing than anything else, but the statistics are staggering. Most people end up needing some kind of long-term care, and the length in which they need that care has extended greatly. So this is why we talk about it with pretty much every single person we come in contact with. Whether you are 18 or 99, we're having this conversation because you may personally experience it or a loved one might. Oh, screen froze and I'm back. Okay, perfect. Thank you for keeping me up to date. Perfect. All right. So the question again then becomes, knowing that unfortunately many people need that kind of care and that the length of that care is going to likely be extended, the next question becomes, how are we supposed to afford it? For all of us living in California, and frankly in this country, most things don't get less expensive, especially when it comes to health costs. And so it really is a big question of how am I going to afford it, or my family is going to afford it if something were to occur. If you live in California, we are only going then to talk about Medicare and Medi-Cal. Medicaid is the program that applies to the 49 other states. But for today, we'll focus again on Medicare and Medi-Cal. Medicare is an age-based program that's really your health insurance. With health insurance, with the health insurance piece, that is looking at, again, your doctor provider, your prescriptions, that sort of thing. And again, it's age-based. So once you hit 65, if you want to be on Medicare, you can apply and then have that coverage. Medi-Cal is not age-based. It is need-based and financial qualification-based. Now, many people are under the impression there is no way they could ever qualify for Medi-Cal because they have heard that if you have more than $2,000, you would be disqualified. And that used to be true. Really quickly to go through, again, why we focus on this so much, we again are seeing the costs are staggering. And so you can imagine if you had more than $2,000 and you couldn't qualify for Medi-Cal, it's a staggering expense, unfortunately, that many families are looking at. So then we do look at, okay, how do you pay for it? For some people, they have the resources, the family resources, the assets to be able to afford it. For others, they had signed up for long-term care insurance. And for what many assume is a select few, they can qualify for government benefits. But I am here to tell you the government benefits piece is actually more attainable than ever before. There's a couple of different reasons for this. One is the fact that at Cope and Barger, we have established, this was about 15 years ago now, what is called a Medi-Cal plan or Medi-Cal trust. What this trust is designed to do is to protect you and your assets and allow you to qualify for Medi-Cal. Now I'm going to break this down a lot. One thing to note, if you qualify for Medi-Cal just on your own and you have a revocable trust and you were to pass away, the state cannot go after your assets after you are gone if they were in a revocable trust. The state can only recover from assets that are subject to probate. So this is another huge reason to have a trust in effect. But for other people, they don't have the resources, again, to pay for this themselves. And so we have a trust that was created here, and it has been challenged by Medi-Cal, and they have been upholding it for about 12 years now. It says you can keep your assets and qualify for Medi-Cal. So that $2,000 number that everybody has heard of, that goes out the door. This is a program and a trust that allows you, again, to, rather than depleting everything you have or getting rid of everything and gifting it away, allows you to retain those hard-earned assets and qualify for a government program that every time you paid taxes, you were paying into. So it allows you to receive at least some of that benefit back if or when you actually had that need. The other huge change, though, and this is where a lot more people actually qualify than they think, is even if you don't have our trust, if you have less than now $130,000, you could qualify for Medi-Cal with or without our trust. So that $2,000 number is out the door. Back July of 2022, they upped it all the way to $130,000. So for anyone who had tried to qualify and was told you're too wealthy, which wealth is a relative term, over $2,000, or you know people who didn't try to qualify because they just assumed they couldn't, it is worth re-looking at, could you qualify now? It's also important to note that that $130,000 number does not include your primary residence. So as long as you maintain your residence as a primary, you don't rent it out, you don't change how you claim it on your taxes, you can keep your primary residence and up to that $130,000. So again, this has greatly changed the landscape. If you have any other questions on this, please do come and talk to us. Essentially, with everything, preventative planning is there to make sure that you have options and choices in effect long before something actually occurs. That's not only for long-term care, that is for everything. Preventative planning is what allows you and your family to have peace of mind and ensure you are taken care of long after you can no longer provide for yourself. And then again, for those of you who have a Cope and Barger trust in particular, there have been some law updates that you need to be aware of. If you have not been to see us since 2018, you will not have these different protection components, or you wouldn't have even had the conversation of, do you need these? I'm going to work backwards on these. If you have special needs beneficiaries, again, come and talk to us. There are a lot of things that we can do to protect them and allow them to receive an inheritance without disqualifying them from government benefits. If you own property in the state of California, so if you own property out of California, you can kind of tune out this part for a second. If you own property in California, now they have limited, unfortunately, to say the only property that your children would be entitled to keep your property tax basis on would be your primary residence, and only if they keep it as their primary residence and live in that property. So the issue here is if you have more than one child and not all of those kids want to live together and want to own that property as their residence, the people or the children who choose not to, their portion gets reassessed as well. So there is, going back to that right of first refusal language that we can put in to allow, if you think a child would want that option and their siblings wouldn't, or you think there's a sequential order of who would, we can put in language that would allow that child to have the option to keep your property tax basis without having any of it reassessed. If you have those protective lifetime or dynasty trusts that I mentioned, and you have your retirement accounts as with the beneficiary as your trust, it is really important that the retirement language in your trust be updated. The Secure Act went into effect just a couple of years ago and says that any child, essentially, who inherits a 401k or an IRA has to withdraw it now within 10 years of your date of death. The problem is if you have outdated retirement language in your trust and you have a retirement account flow through there, it can trigger an immediate withdrawal requirement of that account rather than them even having 10 years. So again, I know a lot of this will probably lead to more questions than answers, but that is because I want to make sure you come in and talk to us so that your specific situation is addressed, because these things are not going to apply to every single person who's here with me today. And the biggest thing that you need to make sure, and this is for every person, and frankly, I think this is a need more than an option, is making sure you have what is called Medi-Cal authority in your trust and your financial powers of attorney. I talked already about the fact you can actually set up a Medi-Cal trust to protect your assets and qualify for Medi-Cal. But what happens if you either choose not to do that trust because you say, I don't want to, you can't maybe afford to do it right now, or you just don't know? What happens though if you were to need that kind of planning, but you had become incapacitated to a point you could no longer sign legal documents? We now have language that can be in your trust that says, if that were to occur where you've become incapacitated, but need this kind of protection, your spouse or your successor trustees and powers of attorney can still set this planning up for you. Again, this is a vitally important piece of information and language to have in your trust and power of attorney. We had a prospect come in just about a month ago whose husband was in need of that kind of care, but because their documents had not been updated with their other attorney to have this language, we unfortunately are not able to provide that Medi-Cal trust protection for them. And that is a heartbreaking thing to have to tell somebody, but it is an extremely simple change you can do to make sure that that is never the answer we have to give you or your loved ones. All right. So for the question I just had about if one had Medi-Cal, should they get out of some other programs? I would say that is more case-by-case specific. I would come and set up an appointment to talk to us about that, because getting out of programs, it's very dependent on what they are providing for you, or getting out of insurance plans, it's depending on what they are providing for you. So on that one, I would want to talk with you more specifically. And then ultimately, for everything we're talking about, it's again making sure that you and your wishes are protected and carried out. And part of that looks at how to leave a lasting legacy. So for many of our clients, they want to make sure that those resources they have built carry on for as many generations as is humanly possible. And there's a variety of ways to make sure that that is accomplished, not only by talking with us, but also making sure you have a good financial advisor, CPA, and any other professional resource that you may need. If you don't already have those people in your life, come and talk to us. We have some phenomenal business partners that we work with and referrals that we can give you to make sure you have all of those questions answered. Then for others, they want to make sure that an emotional legacy is left. The things that they have as far as morals and values, and those items that have maybe some family history or just a really cool story that you think future generations would want to know. Pictures that have who the people were. It's fun to get pictures, but if you don't have someone around to explain who is in them, having that on the back of that photo can make a difference of really establishing genealogy and this legacy that is often for many families lost over time. Again, if you have any questions on this, come and talk to us. This is something that it's not going to cost you to come and talk to us about this because there's nothing we're going to do that is a charge at that point. But it's something that is vitally important to many of our clients and really makes up a large part of the conversation over the years that we have with them. So if you have any questions on financial legacy, emotional legacy, how does your estate plan tie in, and what are some other things to think about to establish those are absolutely things we are happy to talk to you about. Now we are coming to a close, so we again have gone through quite a bit of information. The biggest thing for those of you who already have a trust, or even for those starting out, is to make sure that you understand not only which documents should you have in place, but why it is so important to make sure they keep up to date. We have a life cycle and things change, which means our estate plan has that same life cycle. So making sure you plan when you can, making sure that some of the things that we unfortunately see after someone passes away are avoided. All of that can be accomplished by starting this conversation with us. And you have taken a great step towards doing that. One question I did quickly get is where to list charities. So that is dependent on your goal. For some people, they put them right smack in the middle of the trust is one of the beneficiaries. For some people, we create a separate exhibit that is updatable by clients. And then for others, they'll actually put them as beneficiaries on retirement or other beneficiary accounts. If you're looking to though list addresses, things like that, you can just type a separate sheet with their addresses and contact information. Now, one of the biggest benefits, again, of Koppenberger is we are here to educate you and make sure that you understand what it is that you would need to accomplish your goals. We want to make sure we really go through comprehensive conversations to discuss what does matter most to you. What are the things that we need to focus on and address to make sure that your plan is the one that you want? One question is, how do we put property back into the trust after it is refinanced? That would be by doing another deed. So if you're in the middle of the refinance company might be able to do that. If not, come and talk to us. Now, for those of you who either don't know much about us, don't know anything at all, or just need a quick refresher on why you should work with Koppenberger, it really comes down to our experience and the value then that gives our clients. We are constantly keeping up to date on the laws and what is going on and making sure that as things occur, you have that information too. It is so valuable to have an attorney that presents the information to you and helps you understand how it may apply, rather than you having to go hunt down the information, try to figure out how it might apply, and then get in contact with us. I hate hearing from people who have worked with other attorneys that say, they set up my plan and I never heard from them again. We make sure that we are in pretty constant contact with our clients, whether that is with specific appointments that you have one-on-one or just with the education events that we do all year round. You should never have an attorney where you say, I didn't hear from them for even a year. You should be hearing from your attorney pretty darn consistently, because this is such an important thing to make sure is done correctly and is kept up to date. but we are here to help. So for everybody joining us, the good news is that if you are able to book an appointment within the next 30 days, not even have it, just book it, you actually will have a free consultation. Now, for anybody who is an Access member, and if you have questions on what is an Access member, you can always come and ask us. But if you're an Access member, the consultation with your Access benefit is going to be complimentary anyways. But for everybody else who sat and attended this morning, if you give us a call, you send us a message, and you book an appointment to ask further questions, that would be done complimentary for you as well. Again, we want to make sure that we are as accessible to you as possible. So anytime you attend an education event, you actually do get a free consultation as a result. If you have any other questions, if you have the need to get your either estate planning started or it's time to come in for that review, please give us a call. Thank you again, and I really look forward to working with each of you.